Does Section 76 of the Criminal Justice and Immigration Act 2008, as well as the amendments later made to it, intend to strengthen the position of those who use force against intruders? This is Simran Katani, and today I'll be talking to you about the criminal law on private defence. So Section 76 of the Criminal Justice and Immigration Act sets out the conditions required to use the defence of private defence. Specifically, Section 78(5)(a) states that in a householder case, it is not reasonable for the defendant to use force which is grossly disproportionate for the situation that the defendant believed it to be. It will be argued by myself that Section 76 does not significantly strengthen the position of those who use force against intruders. So, the provisions of the old Criminal Justice and Immigration Act 1967 replaced the common law on private defence in the home with the test of reasonableness, and this test was assessed on the facts by a jury. This narrowed the scope of the defence, and this was further limited by the case of R.V. Martin. This case convicted a farmer for shooting 2 burglars at his house. One died and the other was wounded, and the defendant was charged with murder and attempt of murder. The court found that it was unreasonable for Martin to have used the force he did in the circumstances that Martin perceived them to be, because Martin did not intend defending himself from imminent attack, but instead had intent to kill. This was shown by the fact that he had shot one burglar in the back, indicating the burglars were not posing a threat when they were shot. So although Martin's murder charge was later reduced to a charge of manslaughter based on evidence of a psychological condition that he had forming a defence of diminished responsibility, there was strong media coverage at the time which portrayed the current law as politically corrupt. The view on this was popular, and many saw this law as violating the rights of the householders and not effectively deterring criminals from breaking into homes. Therefore, this case led to the amendments to Section 76 in the 2008 Criminal Justice Act, which stated that in a householder case, the degree of force used by the defendant is not to be regarded as having been reasonable in the circumstances as the defendant believed them to be if it was grossly disproportionate in those circumstances. So, to question whether this did strengthen the provision of those who used force against intruders, we now turn to the case of R.V. Collins. So in R.V. Collins, the claimant attempted to burgle the defendant's home and he suffered personal injury from the response of the defendant. But because of the amendments to the 2008 Act, it was held that the defendant was able to use the full defence with private defence because the force was not seen as grossly disproportionate. Although the claimant issued judicial review proceedings and sought a declaration that the amendment was incompatible with Article 2 of the ECHR, Sir Brian in the High Court stated that there was compatibility, as long as the force used was reasonable according to the test of reasonableness. So this test meant that if the force used was grossly disproportionate, the defence could not be used at all, and if it was not grossly disproportionate, then the force must be reasonable in light of the circumstances that the defendant believes they are in. So at the time, media coverage, such as the Independent newspaper, wrote headlines suggesting that homeowners could always use disproportionate force on intruders following this case. But the law remained that reasonableness was required, thereby only slightly changing the law from the test of reasonableness that was used in Martin. So in some ways, the amendments have made the use of defence of private defence more restricted for householders, as Section 76, Part 5, prohibits the use of the defence for a mistaken belief if the defendant had been voluntarily intoxicated. And this has been cited by J.R. Spencer in his article Using Force on Burglars 2016 as being unreasonable in cases where the householder had only been peacefully drinking at home before a intrusion or mistaken intrusion. So the ruling in Collins has been reaffirmed in the case of Ray, where the criminal division held that force used which was not grossly disproportionate did not make the force reasonable. In the case of R.V. Hussain, the defence of private defence was not available to the householder as the injury sustained by the victim was not as a result of self-defence but as revenge. However, the fact that the crime was only committed because the householder had been acting under extreme provocation after needing to defend himself and his family from the victim was considered in his sentencing. So on appeal for his sentence, the householder had his sentence reduced to 12 months imprisonment. And Lord Judge C.J. considered the emotional anguish that the defendant had faced, therefore concluding that although he was rightly prosecuted, the guidelines in regard to provocation had covered the situation. So this case suggests that although the law on self-defence has not changed from using the basis of reasonableness and imminence, it shows that courts can now take into consideration prior circumstances where self-defence had been required in applying partial defences such as provocation. It seems reasonable that the defendant will be provoked towards the attackers, shown by his statement which claimed he was terrified that the attackers had captured and raped his wife and daughter. This suggests that although he had no legal ground in performing the revenge, he had justified grounds for being provoked, and the attack on the victim was not a result of thought-out, calculated revenge in the typical sense of the word, but of a protective and provoked reaction from the threat the victim posed to the family. So to conclude, Section 76 of the Criminal and Immigration Act does not explicitly strengthen the position of householders in using force against intruders because the amendments only allow for disproportionate force where it is reasonable to do so, therefore using the same guidelines as the test prior to the amendments as illustrated in Collins. However, the provisions give the court more discretion in sentencing as they can assess whether the proportionality or reasonableness of force may affect the length of the sentence, even if the defendant is still guilty of the charge, as demonstrated in the case of Hussein. Thank you for listening.